Something big is happening in California's court system. A new law, AB 1523, is making a huge bet on a different way to handle lawsuits. So let's break down how this law is trying to change the game and create a faster, maybe even fairer path to justice. Look, if you've ever been involved in a lawsuit or even know someone who has, you know the drill. It can be incredibly slow, unbelievably expensive, and just plain stressful. It really makes you wonder, is there a better way to do all this? And California's answer is a really fascinating balancing act. The state is basically saying, yes, there is, and it's betting on this idea we want more cases to go to mediation, but, and this is a big but, we're going to put much stricter rules on how and when it happens. It's a two-sided coin we're about to explore. Okay, so let's dig into what this law, AB 1523, is really all about. You should think of it as a major reset button for a specific part of the legal world, court-ordered or mandatory mediation. So what is mandatory mediation? Well, it's pretty much what it sounds like. A judge looks at a case and says, all right, before you two gear up for a full-blown trial, you have to sit down with a neutral third party, a mediator, and seriously try to work this thing out. The whole goal is to settle things before they get to a courtroom.
But here was the big problem with the old system. For years, lawyers and their clients were saying the same thing. These mediations were happening way too early in the game. You'd get forced into a room before all the facts were out, before anyone really knew the strength of their case. It ended up feeling less like a solution and more like just another expensive, pointless hoop to jump through.
So AB 1523 comes in to tackle this with that two-part approach I mentioned. The first part is all about widening the door, making this mandatory mediation option available for a whole lot more people. And they're doing it with this number. $75,000. This is the new magic number, the new ceiling for how much a case can be worth for a judge to be able to order it into mediation. Now, to really get why this is a big deal, you have to know the backstory. That old $50,000 limit, it hadn't been updated in decades. Think about how much costs have gone up since then. So this jump to $75,000 is a huge and, frankly, long overdue adjustment. So what does this actually mean in the real world? Well, it means that a lot more of those everyday, mid-sized disputes, cases involving consumers or employees or small businesses fighting over a contract, can now be guided toward this settlement process. And that could save everybody a ton of time and money. But remember that balancing act? Part 2 is just as important. While California is opening the door wider, it's also installing brand new guardrails. This is all about making sure these mediations happen at the right time to actually work. This is the perfect way to picture it. The judge is now a gatekeeper. And this new law, AB 1523, lets more people get in line for mediation, but it hands that gatekeeper a very specific and much stricter checklist before they're allowed to open the gate. So what's on this new checklist? Well, a judge can't just order mediation on a whim anymore. A few things have to happen first. 1, the case has to be mature, meaning it's actually been set for trial. 2, the big arguments over evidence have to be settled, no more hiding the ball. 3, at least one of the parties has to actually be interested, no more forcing two people who absolutely refuse to talk into a room. And finally, the parties get a say in picking their own mediator. Makes sense, right? And there are a few more key rules to make the whole process run smoother. For one, the people who show up have to be the ones with the actual authority to make a deal, the ones who can write the check. And it's all on a tighter timeline. The mediation has to be wrapped up 120 days before the trial. And, this is huge, it can't be used as an excuse to delay the trial date anymore. Okay, so that's the new system in a nutshell. But what does it all mean on the ground? Let's talk about the potential upsides and downsides of this big experiment California is running. Supporters are pretty excited. They argue this is going to help clear up crowded court calendars, lower legal bills for a lot of people, and, most importantly, put a stop to all those pointless, wasted mediations. But critics have some valid concerns too. Some say that even the new $75,000 cap is still too low. Others worry that these new rules about when a case is ripe for mediation might be too rigid and could take away a judge's ability to use their own discretion. And just to give you some perspective, here's how this is all rolling out. That old $50,000 cap was set ages ago. This new law, AB 1523, was passed in 2024. But, and this is a key detail, that new $75,000 cap doesn't actually kick in until January 1st, 2027. So the legal world has some time to adjust to the new rules of the game. Now, it's really important to zoom out for a second here. This law didn't just pop up out of nowhere. AB 1523 is actually part of a much bigger shift that's happening in our justice system, not just in California, but all over the country. This quote from some policy experts just nails it. We're seeing a move away from ad hoc or, case-by-case alternative dispute resolution. Instead, we're moving toward making things like mediation a structured, criteria-based part of the standard process. It's less of an alternative and more of just the way things are done. So, what's the bottom line here? The message for anyone tangled up in a civil case in California is crystal clear. If your case is under that $75,000 mark, mediation isn't just some optional side quest anymore. It's becoming a central, rule-bound, and totally standard part of the whole journey. And all of this leaves us with a really big, thought-provoking question. As settlement becomes the new standard operating procedure, especially for these mid-sized cases, what does it really mean anymore to have your day in court? It's a fascinating change, and we'll be watching to see how it all plays out. Thanks for tuning in.